The motion for summary judgment. This is what most cases come down to, is the motion for a decision without a hearing, otherwise known as a motion for summary judgment. This is something that is usually filed by the agency's attorney, or it's filed by defendants or the employer. However, plaintiffs can file this too. This is going to be a walkthrough of this. Judges also issue notices of intents to issue summary judgments. So judges also may dispose of your case without a hearing on their own initiative. And when they do that, that is a judge issuing it sua sponte, on their own initiative. And so it's very important to remember that most cases may come down to this motion for summary judgment phase. What does this mean? This means that you may not have your day in court if the agency has something to do with that. They are trying to say, Judge, we do not need a hearing on this case because the plaintiff, the complainant, the employee cannot prove their case. There are no material facts in dispute and therefore no hearing needed. Well, where does this come from? Well, this comes from the regulations, Title 29 in the Code of Federal Regulations. And we want to go down to Part 1614, and that basically takes you over to the section that deals with summary judgments, which is in the hearing section. So it's 1614.109G. So this is sometimes referred to as a 109G motion. And this deals with summary judgment. And it basically says that if a party believes that there are no material facts that are in dispute, then you can submit a statement with the administrative judge prior to the hearing. And so that's what's key about this, is that this is something that is done prior to a hearing. And you're basically saying that there are no material facts in dispute, and we need you, Judge, to resolve this in our favor. And so if it's an agency, they are trying to dispose of your case prior to a hearing. You have an opportunity to respond to this. Generally 15 days. By regulation, it is 15 days, although the judge may set different timelines. But you have at least a minimum of 15 days. And when you're responding to the motion, you have to respond with evidence. So you can respond to the record or the report of investigation. You may also respond to using affidavits or attaching other exhibits that are not in the ROI. And so it's very important that you do that. Otherwise, the judge can issue a decision without a hearing. All right? So this could mean that basically your case is over and that you have to deal with appeal options if it's ruled in the agency's favor. Again, we looked at a judge doing this on their own initiative. A judge can do this on their own initiative. So his or her own initiative, they may file the same thing. And so basically the two are going to be talked about interchangeably here, because whether it's the agency filing it or whether it's the judge filing it, it's still going to end up in the same end result, which is an order either denying the motion or limiting the scope of the hearing or issuing a judgment, a decision without a hearing. So this is a powerful tool that can be used by both parties. We talked about the acknowledgement and order that you get and how there's certain things that get talked about, including a summary judgment or a decision without a hearing. This is something the judge will set. The judge will remind you that you should be mindful that most cases are resolved through summary judgment. So this is an order, a sample order, where it says that. And you have to keep that in mind for settlement considerations. This is a sample motion for summary judgment or motion for decision without a hearing using a fictional character in the year 2099. So there's that regulation again, 29 CFR 1614. And there's the language from that regulation that the agency is citing. They're saying that there's no material facts in dispute. Here are the issues, Judge, and here is the legal standard. And here we go again with 109G, 29 CFR 1614.109G. And there are no material issues of fact according to the agency in this motion. And this is the statement of undisputed material facts and argument. So the agency will lay out the facts, and then they will lay out the argument, and they will say that they will apply those facts to the argument, to their legal standard, and conclude that you cannot meet the legal standard, and then they will ask that summary judgment be granted in its favor. This is a sample response that we file using the same fictional scenario here. We respond and we oppose the agency's motion for summary judgment. All right. We cite the same language, 29 CFR 1614.109G. Again, agency's motion for summary judgment or decision without a hearing, those two terms are used interchangeably. In the federal litigation world, those two things are used interchangeably. And we respond to it, and it's important to respond to it with argument. All right, again, you'll see the same regulations, you'll see the same legal standards, and we will, of course, argue that you can meet the legal standard. Here's the crux of every argument. The essence is that there are credibility issues. There are factual issues that can only be resolved at a hearing. We have sufficient evidence to support a prima facie case, an essential case. And we can show that there's pretext for discrimination. That right there is the crux of every response, or the essence of every response, usually, generally speaking. And we ask that the agency's motion should be denied in favor of you. So keep these things in mind when you are served with a motion for summary judgment, that you must respond to the facts and create a genuine issue for trial.